For delivery of judgment, item number 1.
In the light of the principle laid down in so and so, this court finds no ground to interfere with the impugned order in exercise of jurisdiction under Article 227 of the Constitution of India or Section 115 CPC. According to this, civil division petition is dismissed as not maintainable. Okay. Liberty granted to the petitioner to avail a remedy is available.
Anybody want to mention the matter?
We are having item 15 and 16 for hearing. And I have been told there is a election case also for cross examination.
Yes, yes.
Would it be possible to take up a matter, or if not, then
So when do you want?
first and second of April.
Second. First.
First and second of
Se-
April.
Second.
First of April.
My
First
lord,
of April. Okay.
my lord, may be pleased to fix 2 dates because as per the understanding earlier, my lord, it was taken up on a back-to-back
Okay.
basis.
Your lordship
And
indicate
Lord
that
AG also probably is inconvenient for
if
him
it is
today.
not completed on 1st of April, it can continue on 2nd of April.
Okay.
This will take a lot of time.
Okay.
Interim order granted earlier, that may continue. On the last occasion, 5/1/2022.
On the,
Hello.
it will be a joint prayer only.
Joint
On the joint prayer made by both the Lanka Council for the parties. Let this matter be listed on 1st April, huh?
1st of April.
1st of April for hearing.
The matter still children.
Okay, 1st of April, huh? So on the same day you can pay? On the 1st April,
No?
if it required to be continued? Okay,
What if
They observed that it will continue on day-to-day basis, my lord, as per the
Okay.
earlier.
similar
So-
to continue?
okay. As first item in the hearing list, okay? And if required, sorry, if it is not, okay, if it is not completed on 1st, the same may also be listed on say 2nd. Okay.
So the interim order passed on 5/1/2026 will continue.
The impugned order passed earlier shall continue till the next date of listing. Okay.
It is actually an interim arrangement, my lord, not an order, because the court had not passed a judicial order. It was based on a commitment that the matter would be taken up on a day-to-day basis. We said that we will not pursue the execution.
Is it interim order?
Yes. Paragraph 4 and 5, 5/1/2026.
Okay.
Order dated, last order, my lord, 5/1. In my lord, LA appeal 2 of 2022. Last order.
Order dated?
5/1/2026. There are 4, 5 and 6. Those are.
Paragraph
There are
5,
4,
1.
5 and 6. My lord. All 3 paragraphs. My lord. Your lordship has
Consensual able to fix the matter on notice issued. Okay, notice. Stay the notice.
yes.
And execution
And execution proceeding also.
It is stay only.
Yes.
that may be continued.
So that may be continued. My lord.
Okay.
Okay.
The interim order passed on 5/1/2026 shall continue till the next date of listing. Okay,
My turn.
okay,
Mayor,
yes,
Lordship, I'd like to mention one unlisted criminal petition to purchase of this for 25.
on this date,
Unlisted criminal petition. Letter was heard on 13 October 2025, and it was fixed for PCR. And it's for PCR, and it was to be heard after 4 weeks. It has been 11 weeks almost. So
okay, you want that matter to be listed?
Yes, Lordship,
Okay, tomorrow.
tomorrow. Okay.
Yes.
Yeah, Your Lordship. Your Lordship, I wish to mention item number 14. I'm appealing on behalf of Deepangi. Taken consent from the other parties. Kindly this meeting will be fixed after 2 weeks.
The Kipang is,
Petitioner. Petitioner.
okay, petitioner, he is out of his session.
No, Your Lordship, due to some personal difficulties.
Okay. Who is for the other side?
Marto Kato.
Have you informed?
Yes, Your Lordship, I have taken consent from others.
Okay. Mr.
Sita Jo, appealing on behalf of Deepangi.
Sita Jo submits that the conducting counsel, Mr. D. Pangan. No, Mr. D. Pangan, counsel for the appellant. He is unable to appear at the court today due to some personal difficulty, therefore pray for adjournment. He has also obtained consent from the line counsel of the other side. The line counsel for the other side. Adjournment for how much time?
Your Lordship, 2 weeks.
Okay. Okay, great for Tama. List is matter after 2 weeks. Okay.
Hablas.
Item number 2.
Yeah, my lord.
Yes.
This revision, my lord, is against arrest, against my arrest on, my lord. On the execution suit, my lord, filed by the respondent. My lord, here it
Against
is,
the,
yes, against the execution case, my lord, execution suit filed by me, filed against me, my lord.
that's it.
My lord, here I am the judgment debtor.
Okay.
I am the judgment debtor. I have been arrested, my lord. Page 76, my lord.
Okay, yes. What is wrong in it?
My lord, non-compliance of section, order 21, rule 39, my lord.
Hmm?
Subsistence allowance was not deposited, my lord. After my arrest, the subsistence allowance was deposited.
Subsequent
Subsistence allowance,
or subsistence allowance?
yes, my lord.
So that amount to
Procedure left, my lord.
procedure left.
Yes,
How?
yes, my lord, page 76, my lord. I was first arrested, my lord. And then, my lord, the executing court, my lord, has directed to deposit the subsistence allowance, my lord. It has to be first deposited. my lord.
First deposited.
Yes, subsistence allowance should be. Order 21, my lord. CPC, my lord. This, my lord,
So it was not time, not deposited on time.
yes, my lord.
So what jurisdictional error committed thereby?
Procedural lapses, my lord, completely. And, my lord, this village authority, my lord, is from model village authority. They have passed the decision, my lord.
Hmm?
Model village, village authority of model village, they have passed the decision, my lord.
Have you challenged?
My lord, by this revision, my lord, yes, my lord. Because it is a nullity, my lord, because it does not have the jurisdiction, my lord. I am from New Delhi, my lord. The decree holder is from Dam side, my lord, Nahalagan Dam side, my lord. None of us reside in the model village, my lord.
So where, how do you show the jurisdiction?
Jurisdiction, my lord.
Have you raised in the initial stage before the GB?
My lord, we are ready to comply, but we need some time, my lord. We have been submitting on it.
Then how do we grant? How do in the civil revision?
We are raising the, my lord, firstly on the lapses of procedure of CPC, my lord. And my lord, without any authority, my lord, the village authority has passed this.
So what procedure? Is it,
It is mandatory, my lord.
is it
Order 21, my lord.
order 21?
Yes, my lord. 21 rule 39, my lord. Now, without complying this provision, I have been arrested. After arresting me, my lord, the procedure was followed. Rule
Thereby what jurisdictional error has committed?
jurisdiction error, my lord.
He has a jurisdiction,
No, my lord.
the execution authority,
Executive authority, yes, my lord. But the
the
decree,
executing
decree, but
court
decision
has
itself,
authority to execute. Otherwise,
the village authority, no, my lord. EAC has passed the execution order, my lord.
okay. So who, according to you, should pass?
Yes, my lord, they can, EAC can.
EAC can, EAC
Yes,
can.
yes, my lord.
Then
But there
what's
is a
wrong in
procedure,
it?
my lord,
In
that
it?
has to be followed, my lord.
Hmm?
Procedure, there is a procedure that has to be followed, my lord.
What
Me-
procedure? But EAC has the jurisdiction to pass such order.
Yes, my lord.
Then
They can execute, my lord.
you are coming under which provision?
My lord,
115 only.
yes, my lord. Subsistence, else, may I read, my lord? Order 21, rule 39, my lord.
Order 21 rule.
39, my lord. Subsistence allowance. No judgment debtor shall be arrested in execution of decree unless and until decree holder pays into court such sum as judge thinks sufficient for the subsistence of the judgment debtor. First, my lord, they have to pay, my lord, subsistence allowance. Before payment of the subsistence allowance, I have been arrested, my lord. After my arrest, the procedure was followed, my lord.
You were absconding, it appears.
No, my lord.
And then when you were arrested, on the same day order was passed. 16,
Yes, my lord. That's why after arrest only this procedure has been followed, my lord. 16 day, 16 on 16 I have been arrested on the
on the same day it appeared, the order was passed
Yes, my
to
lord.
deposit
So
amount
before
of
my arrest,
rupees 12
it has to be followed.
12,000, 12,000, 6,000. On the
200.
same day
Yes,
when you were arrested.
so it should be before my arrest, my lord.
So what's
After
wrong in it?
It-
What jurisdictional error has committed?
Error, my
thereby?
lord. Yes, my lord. Let's,
It's
my
not
lord,
a,
please come to page 30, my lord.
who has passed this? Assistant Commissioner.
Yes, my lord.
Assistant Commissioner has a power to pass this.
Execute, it can execute the.
Okay, then he has a jurisdiction.
Yes, my lord.
Then
Jurisdiction,
what
but
is
the
the error? Where is
procedure
the
was not
error?
followed, my lord. Procedure prescribed, and my lord. And my lord, may kindly come to page, I'm sorry. Section 55, my lord. There was no satisfaction that I am not willing to pay, my lord. That there was my bad intention not to pay, my lord. Section 55 CPC, my lord.
You can make a prayer before the same court. Why it is under the revisional jurisdiction? Can that be revised?
Yes, my lord.
How revision lies against such order passed by the court which have a jurisdiction? No jurisdictional error has committed. Come to the 115. Read 115.
Yes, my lord. To have exercised a jurisdiction not vested in it by law, my lord.
Hmm.
To have failed to exercise a jurisdiction so vested.
Yes.
To have acted in the exercise of jurisdiction illegally or with material irregularity, my lord.
Where? Then
So, my lord,
where is the jurisdictional error?
yes, my lord. Non-compliance of order 21 rule 39, my lord. It's long before, my lord, it has been settled, my lord.
See,
In
the
the case of
procedural
Varghese
fact
Park.
and the law cannot be. In the
Fine.
fact, if there is error in fact and the
Well,
law,
I
how
cannot
do we
challenge the order of
interfere
execution
in the
court.
revision? Hmm?
I cannot challenge the order of execution court in appeal, my lord. It has to be before revision.
Yes,
So, my lord, the material irregularity is there, my lord.
so irregularity, how do we correct in the revision court, by the revisional court?
It can,
Unless there is a jurisdictional error, unless this,
the procedure has to be followed, my lord. The irregularity has been there.
hmm?
Procedure has to be followed, my lord.
Yes,
Material irregularity, my lord.
what material irregularity?
My lord, may also please come to page, sorry, section 58, my lord. Detention and release, my lord.
Section,
58, my lord.
what it says?
It's a detention and release, my lord. So, my lord, order 21, rule 39 should be read with section 59, my lord. So the procedure is, my lord, before my arrest, it has to be followed, my lord. The amount so has to be paid, my lord. On the omission by the person whose application has been so detained to pay substantial loss, my lord.
Section 58,
Section 58, Roman 4, my lord.
what is it on the omission?
By the person, my lord, on whose application he has been so detained to pay substantial loss, my lord.
What?
My lord, order 21, rule 39 should be read together, my lord. So before my arrest, he has to pay the substantial loss, my lord. So the procedure was followed after my arrest, my lord. Entire procedure was followed.
But then he say, on the same day, subsistence allowance was paid
Was directed to pay, my lord.
on the same day.
Was only
So
directed
he
to pay.
paid on 17. 16, it was directed on the
Yes,
same day.
ma'am.
How do?
16, I was arrested, man. Already
Yes, on
arrested.
17, immediately on 17, order was passed on 16, on 17 immediately paid. What's wrong in it? It's only for, he complied, the judgment, the decree holder complied, immediately complied. Immediately on the next day, this order is probably was passed in the morning or afternoon after obtaining order paid. What's wrong in it?
I was arrested on 15 February, man. 16th February, I was brought before the magistrate, man.
Yes, it was produced before the magistrate.
Yes, ma'am.
You were absconding.
No, my lord. I was
After arrest, you were produced before the magistrate, sorry, the executing court on 16, and on the same day, the order was passed. And immediately on the next day, he deposited. What is the jurisdictional error committed there?
not-
how the
material
result
irregularity,
lie?
is there, my lord. Irregularity, man.
What irregularity?
After my arrest, entire process was followed, my lord.
Hmm?
After my arrest, my lord, entire process was followed.
To arrest you also, it took time. You were issued a so-called notice. And then you were absconding, police
So,
reported,
notice was not formally
thereafter,
issued to me, my lord. It was
thereafter,
sent-
ultimately you were arrested and then produced on 16. And then on 16 only this order was passed. And then only on 16 it was committed. Before that, how would know the applicant? Because you were absconding
No, my lord.
immediately only after passing order, direction to deposit the amount on 16, immediately on 17, he deposited. What is the purpose of some
My lord,
depositing?
from since
subsistence
from
amount?
beginning, we have been seeking time, my lord. We are ready to comply with the order, my lord. My lord, may please come to page 29.
That application you can make before
Yes. So,
The-
my lord,
executing court.
yes, my lord. That we have been submitting, my lord.
Hmm?
So, my lord, before coming to the conclusion to arrest me, my lord, they have satisfied that I have some bad intention not to pay the decretal amount, my lord. There
Why
is no
you had to wait till your arrest?
I have been, my lord, making application, my lord. I may be given some time to pay the
For
decretal amount, my lord.
That application you should have made before the executing court. Rule 40. Such application lies before the executing court only, huh?
The satisfaction has to be there, my lord. Or in para 15 also, we have submitted that we were not served with the notice, my lord,
31.
formally. We were sent notice through only through WhatsApp, my lord, which is not a mode of communication. my lord. My lord, we are submitting that we are ready to pay, my lord.
That application we make before the,
We are also submitting
Executing
before this honorable court, my lord. We may be given 6 months time, my lord.
but how this revision lies?
Revision, my lord, there is a procedural lapses, my lord. Complete
Procedural lapse cannot be revised.
material irregularity is there, my lord.
Order to be-
Non-compliance of order 21, my lord. And section 55 also, my lord. Section 55, 58, my lord. May I read section 55, my lord? Section 55 will be important. Section 55, subsection 3, my lord.
I mean, Council, your remedies lies only before the executing court only. You can make necessary application before the executing court, and then you show your bona fide by depositing amount if you are ready.
Yes.
So revision in any case doesn't lie. I don't see.
My lord, for
There is
violation of
no any you said yourself, your
material
says that
irregularity, my lord.
admittedly he has a jurisdiction to pass such order. He is
Executing
passed
court, yes.
accordingly.
But there has been, my lord, procedural lapses, my lord. Complete
What
procedural
procedure
lapses.
left?
Well, first I was arrested and then the procedure was complied.
Whether the procedural lapses cover under this 115?
Yes, my lord.
How? So
Yeah, my lord. Section 115, yes, my lord.
satisfy the court that
Yes, my lord.
procedure lapse. For the
115,
procedure lapse, revision.
You have acted in excess of his jurisdiction illegally or with material irregularity.
Where is the material irregularity and illegal
Not
committed?
following our procedures, my lord. Order 21, my lord. After my arrest, the procedure was, my lord, followed, my lord. It has to be before my arrest, my lord. Order 21 is very clear, my lord. Order 21, Rule 39, my lord. May I? No judgment after shall be arrested, my lord, in execution of a decree unless and until the decree.
Section,
Order 21, my lord.
Order?
21, Rule 39. Rule 39. Sub Rule 1. No judgment debtor shall be arrested, my lord, in execution of a decree unless and until decree holder pays into court such sums as the judge thinks sufficient for the subsistence of judgment debtor from the time of his arrest until he can be brought before the court. So the procedure has to be before my arrest, my lord.
Sufficiency of the judgment letter. From the time of his arrest.
No, my lord, the judgment, no judgment debtor shall be arrested, my lord.
Okay.
In
Read-
execution of a decree unless and until my lord,
Hmm.
the decree holder pays into the court for the sums as the judge thinks sufficient.
Yeah, the judge thinks sufficient,
Yes.
okay, for the
So it has
sufficient,
to be before my arrest, my lord.
read complete sentence,
Yes, ma'am.
thinks sufficient for the subsistence of the judgment
Judgment
debtor.
debtor from the time of his arrest.
From the time of his arrest,
Yeah.
from the time of his arrest only. Immediately from the time of his arrest, order was passed, he immediately deposited. What's wrong in it?
Our statement is, my lord, on 15 I was arrested, my lord. 15 February.
15 February.
Yes, my lord. The order is of 16, my lord. 15 I was
But,
arrested.
but he
16
was
I was
produced
brought
before
before
the
the
executing
magistrate.
court on 16 only.
15 I was
15,
arrested.
15, at what time he was arrested? He was arrested by the police. It was
Yes.
not yet produced before the executing court because he was, you were absconding.
No, we were not.
On 16, he was produced before the executing court. And
Yes,
on
ma'am.
16 itself, the order was passed.
Yes, my lord.
And accordingly, he deposited. What's wrong in it?
So
It
the
says that
procedure,
until,
my lord,
from the time of his arrest, until he can be brought before the court.
this, my lord,
No,
15
I
I was
think,
arrested, 16 I was produced. My lord,
No, revision doesn't lie.
then my lord, section 55, my lord.
And then you have challenged. What is this?
Section
us see your-
55, there has
let
been
us see your
satisfaction
prayer.
from the executing court,
Let
my
us
lord.
see your prayer. Without satisfying that there is a jurisdictional error, you have made a prayer for quashing and setting aside of the impugn order so and so, and really immediate release.
That is my
See-
another ground, my lord.
And then you impugn mail order also you are challenging.
Yes, my lord. That is nullity, my lord. My lord, may I please come to page 46.
Have
my
you
lord.
challenged this? How have you
Yes.
challenged this?
By this revision,
What
yes.
jurisdictional error the mail order committed?
Yes, my lord.
By
Page
passing
46,
this
my my lord, may I please come to page 46, my lord.
Hmm?
Page 46, my lord. This is the customary code of model village, my lord. Now, both the plaintiff and the defendant, my lord, both of them does not reside in model village, my lord. Page 46, my lord. In the customary code of model village, Nahalagan, my lord.
Where have you shown the jurisdiction of this court, this Gambaras?
My lord,
This Gambara cover which village?
model village, my lord.
Model village.
Yes, my lord. Now, my lord, the coast title, my lord. Toko Bapu, my lord, the plaintiff, my lord. He is a resident of Dam site, my lord.
Presently residing.
Yes, Dam site, my lord. And I am a resident, my lord, of New Zealand.
They are basically from model village.
Yes. No. Dam site, my lord, is Nahalagan, my lord, here only. Model village is, my lord, the Kankar Nala, my lord. And I am, my lord, from New Zealand.
Have you raised this before the
My
court?
lord, this decree itself,
Before the
this
GB.
decision is itself.
Where is your application? Let us see your application before the GB that you don't have any jurisdiction to decide the case. You have an objection. Where is your application? Let us see. Page,
This decision, my lord, it's itself, it's a nullity, my lord.
how?
Because without jurisdiction disorder, decision has been passed, my lord.
Where is the objection raised by you?
My lord, any authority can pass any decision, my lord, which is it, my lord, which does not have any.
You did not
legal
say, you never say that the
Oh, this
Gambara
order does not have any legal
or the court
significance, my
has
lord.
no authority.
By this revision, we are, man. When the decision itself is a nullity, my lord.
Can you show the jurisdiction of the model village?
Model place, my lord. Section
Oh,
5 of.
Let the
of our
opposite
state,
party appear. Let the opposite party appear. You take steps.
my lord, for interim, my lord, we may be granted.
No interim.
So that we can
No.
arrange some for payment of the decree, my lord.
You
Decree,
pay
my lord.
immediately, you will be released only. It appears.
My lord, I am inside the prison.
This application we can make, always make before the executing court.
My lord, we have made, my lord.
Hmm.
We have been.
Where?
Time, my lord.
Where? After default, you
Para
thought that
15, my lord.
they will not do anything, cannot arrest. And then when you are arrested, then
By being inside the prison, my lord, I cannot pay, my lord.
you were given enough time, I think. decision was done in the 2025 only.
This is
And
page,
for
page
arrest
66
also,
is
arrest
our
also
application.
it appears warrant of arrest before the
Page 66,
show cause notice. See the show cause notice. On
Page
several
66
occasions,
is our
show cause notice, order was passed. Then show cause warrant, you remain execution, you remain absconding. Then again warrant.
Malad, we were not served with the notice, Malad. Only through WhatsApp, Malad, which is not an accepted form of communication, Malad.
Have you challenged those?
Yes, Malad.
You could have made an application before the executing court
Yes, Malad.
and then no appeal was
Page
filed
66, Malad.
no appeal has been filed against
Malad, against the
Decree.
order of executing court, there is no appeal license.
no decree.
Malad, by revision also we can challenge, Malad. Because the village authority does not have any jurisdiction, Malad. The plaintiff itself is from them side, Malad, and the defendant is from Malad, Nirjuli, Malad. How the model village authority has the jurisdiction, Malad? No cause of action lies in that model village, Malad.
And why you have made this Gambara also as a,
Because it has passed Malad decision without any authority, Malad.
okay. So tomorrow if the district judge passes, whether you'll implead him,
No, Malad. But there is some malafidiness, Malad.
where have you made any allegation? Who will represent this? Okay, Gambara by name.
They have deliberately acted upon a jurisdiction which they were not authorized, Malad.
Where have you made an allegation against Gambara for?
Page 16, Malad.
Yeah.
That the assistant commissioner failed to appreciate para 20, Malad. The mail order is a
Is it
jurisdictional.
wrong?
Yes, Malad.
Hmm.
That the assistant commissioner failed to appreciate that the underlying mail order is a jurisdictional nullity, Malad. As
How
per-
he will appreciate? What power he has the executing court? You should have challenged this before.
Or if the mail order itself, Malad, the decision itself is a nullity, Malad, there cannot be any.
Sir, have you
execution.
challenged the decision?
Yes, Malad.
For that, you have to challenge the decision only.
Yes, I have challenged, Malad, by way of this revision. Our High Court says, Malad.
Now, unless you challenge,
Yes, Malad.
then the executing court cannot change the decree.
Our High Court says, Malad, if the decision itself is a nullity, Malad, it can be challenged in any collateral proceedings. Two thousand 3 GLT, Malad, page 45. Malad.
Now,
Our decision itself is a
where have you stated that the Gambara has no jurisdiction, had no jurisdiction?
yes, Malad. 16, Malad, para 20. Para 20, we have said, Malad. Page 17 is the continuation, Malad. The assistant commissioner assistant commissioner is the executing court, Malad, failed to appreciate that the underlying mail
Oh,
order.
how how the executing court will remand back?
Malad, by
Unless you
revision,
challenge,
I am challenging the entire proceeding.
unless you challenge the decree itself.
Yes, Malad, I have challenged the decision, Malad,
Where?
in this revision, Malad.
What are you saying, learning council?
Malad, when the mail order is itself is without jurisdiction, I can challenge, Malad. By
You
way of
are-
revision, Malad.
You are asking
Yes,
the executing court to send it back. Unless you challenge the decree itself, how the executing court will send it back or remand back?
no, Malad, I have challenged the decree, Malad.
Read the para 20, para
Prayer
20.
6, Malad.
Hmm?
Page 23, Malad, prayer 6, Malad. for causing and setting aside of impugned mail order.
Where's
dated
your statement that the mail or the Gambara didn't have the jurisdiction? Where is your statement
Yes,
in the
my lord.
pleadings?
Para 20,
In the
my lord.
pleadings,
Para 20, my lord.
this is ground.
Yes, my lord.
Ground only says
Yes, my lord.
that kindly read the sentence. Read the entire sentence.
Yes, ma'am. The Assistant Commissioner failed to appreciate that the underlying mail order is a jurisdictional nullity as per 2023 amendment of section 4 of the so-and-so. Cases must be referred back to the concerned village authority within the territorial jurisdiction.
Who has the power to remand back? Whether the executing court has the power to remand back,
No, no, no.
then what are you saying?
Now, my lord, ma'am, please, may I continue, my lord? Since the part,
Executing court doesn't have even a power to change even a comma
yes,
of the decree.
yes, yes, of course, my lord.
So how he can remand?
No, my lord. My lord, may I continue the reading? Ma'am? Since the parties here belong to different jurisdiction, the model village head.
This you should have challenged.
Yes, ma'am.
This
Yes.
is the ground of, you see, ground
Yes, ma'am.
of the order passed by the executing court only.
Yes, ma'am.
Where have you stated in your pleadings that he doesn't have a jurisdiction? I'm challenging, you are challenging on the jurisdiction ground. Where?
Para 7, my lord. Page 7, ma'am. And even in para 6, my lord.
Para 7 what?
May I read page 6, ma'am? Para 6.
Para 6.
That the petitioner further begs to state that the model-based customary court head Gaupura lacked the inherent territorial jurisdiction to adjudicate the dispute in question. Both the petitioner and the respondent reside in different jurisdiction, and the purported transaction did not occur within the territorial limits of model village. Under the existing legal framework of state, such inter-jurisdictional dispute between indigenous parties must be referred to a competent inter-village territorial customary court or an apex customary court. However, the model village head Gaupura arbitrarily assumed a jurisdiction and proceeded to pass an ex parte judgment without any legal authority to do so. Additionally, the requirement of 3 consecutive willful absence from
That was also fulfilled.
Oh.
Fee notice clearly given in the game of 30 days, and thereafter only ex parte order was
no, my lord,
passed.
no formal notice was served to us, ma'am. Only through WhatsApp, my lord. WhatsApp is not an accepted communication, ma'am. Now, by para 6, my lord, we have challenged the authority of the village, model village Gaupura.
Had Mr. B. Picha, land
Madam,
counsel for the
lastly, ma'am.
petitioner.
May I read my last one judgment, my lord?
What the-
Our High Court judgment. This issue of jurisdictional error, my lord. The nullity, my lord, this part can be raised in any
See.
proceeding, my lord.
You are aggrieved by the mail order.
Mail order, yes, my lord.
Then it should have been appeal.
No, my lord, in revision also I can tell, because it does not have the jurisdiction, my lord. If it has the jurisdiction, I have prepared appeal, my lord. But it lacks the jurisdiction, my lord.
Where is the application that you raise the jurisdiction, the incompetency of the Gambara?
In the proceedings, we
You
have,
have never raised.
yes, my lord.
Decree passed. Against the decree, appeal lies. It's appealable order.
Well, when the
Appealable
village
judgment.
authority has a
Disposal
jurisdiction,
and
yes,
appeal lies.
when the village authority has a jurisdiction, then appeal lies, my lord. When the village authority does not have the jurisdiction, my lord, it is a nullity, my lord. And the executing court is, my lord, executing a nullity order in nullity, my lord. Regarding the issue, my lord, I would like to read one judgment. Para 5, my lord. Internal para 20, my lord. Insofar as the second issue is concerned, it is true that the executive
Para?
court, internal para 20, my lord. Para 5, my lord. Insofar as the second issue is concerned, it is true that executing court cannot go behind the decree and grant interest not granted in the decree as submitted by the council appearing for the appellants in the light of the decision by the, referred by this court in the state of Punjab versus Kalyan so and so. But if a decree is found to be nullity, the same could be challenged and interfered with any subsequent stage. at any, at the executing stage or even in a collateral proceeding, my lord. This is a collateral proceeding. This is in view of the fact that if a particular court lacks inherent jurisdiction in passing a decree or making an order, a decree or order passed by such court would be without jurisdiction and same is non as and void ab initio. What I am saying, my lord, that is void ab initio, my lord. In the court title itself, it has been written, my lord. The plaintiff is from them side, my lord.
You have never objected,
Still now we
you
can raise
accepted,
objection.
and then you made, even made a prayer for some time. Okay, this is,
Executing court is, my lord, executing a void order, my lord.
this petition has been filed under section 115 of the Code of Civil Procedure 1908.
Cause of action does have never arisen in the model blade.
Challenging the
Neither the plaintiff or the defendant reside in model blade.
order dated 16/2/2026 passed by the executing court
What I am submitting, my entire proceeding is shame, my lord. Since the mail order decision itself is a nullity, my lord.
you have only in the course title only you challenged order dated 16/2 executing order only. Order passed by the executing court.
In the prayer, we have challenged the entire proceeding, my lord. Entire decision itself also. My lord, in page 2, my lord, of my course title also, I have challenged the mail order, my lord.
Okay, challenging the following, huh?
Yes, for causing and setting a impugn mail order dated
The order,
18 September.
order dated 16/2/2026. And you are challenging a committal order also.
Yes, my lord. Entire subsequent proceeding, my lord. After the mail order, my lord. Even the mail order, I have challenged.
Whereby he has been. Where is the order? Okay. Direct, the 16/16, what order was passed?
16, my lord. 16, I was, my lord, committal order, my lord, for 2 months, my lord. Mail order starts with page 30, my lord.
Arrested and committed to the civil prison in execution of the mail order dated. Mail order when it was passed?
On, my lord,
18/7.
18/7, yes, my lord.
Mail order dated 18/7/2025 passed by the which Gambura
Model place, my lord.
the where do I find? Where is it? Okay.
Page 35, my lord.
Passed by the Teba of Model Village, Nahalagan Circle. Nahalagan Circle, it covers Nahalagan, huh?
My Section 5 has to be appreciated, my lord, in that case, my lord. Section 5 of the AFR, my lord. There cannot be a circle, my lord, because it has to be confined to village, only village, my lord.
You are even claiming, what is this? Compensation
Yes, my lord, because,
or in the revision?
my lord, I have been arrested, my lord.
Revision, I think we need to understand revision properly.
There has been complete lack of jurisdiction, my lord. On the basis of lack of, my lord, authority, I have been arrested for, and I have been in prison for more than, my lord, 7 days, my lord. When the order itself is a nullity, my lord, why I am
Okay.
inside the bar?
Issue notice. The petitioner shall take.
Uh,
step
The interim, my lord, in the interim, I may be released, my lord.
for serves notice upon the respondent by a speed post as well as by usual process within a week from today. Staff call for the then a call for the record. Staff list this matter. Then steps within 2 days. Okay.
My lord,
List this
my
matter
lord,
next week.
in the interim, my lord, I may be directed to release, my lord.
No interim. It appears there is a problem. What interim order can be passed here?
I may be allowed to direct to release, my lord.
How? On what basis? In a revision?
Yes, my lord.
How?
Because the order itself is nullity, my lord.
You have not challenged the order itself.
Yes, I have challenged, my lord.
Okay. List this matter next week. Okay.
We have also submitted that we are ready to pay, my lord, within
You
6 months.
pay, that is why I'm saying,
Uh,
all remedy lies before the executing court only. You show your the bona fide, submit there, deposit there, and make an application there, appear there. You have never appeared. That is why this recourse was taken, it appears. You appear there, make a prayer, and deposit some amount, you will not be taken into custody also.
We are
And
ready
you are
to comply.
challenging, now you are.
Though we are
claiming
saying the
compensation.
order itself is nullity, my lord, but we are ready to comply, my lord.
No, you have also indicated somewhere that
Yes.
you are ready to pay, praying
Yes.
for time,
Yes,
and you fail
yes, my lord.
again and again. That is
So, my
why
lord, then there is a complete violation of section 55, my lord.
why you did not raise there?
Yeah, I have raised, my lord. Here I have raised, my lord.
Well, it's too late now.
My lord, interim may be.
You could have raised there, and then even after you raised those objection or whatever, then if the executing court or the mail fail, then only you can come here.
My lord, the executive
But
court
then
should have.
you
a
have never
satisfaction.
raised there. You accepted there. You sought for time, and now you are raising
My lord,
after arrest, and then you have not appeared
my
for the
lord,
bail also.
executing court should satisfy, my lord. I have bad intention not to pay, my lord. I have been submitting that we are ready to pay, my lord.
Where?
For grant.
No. That is only after you have been arrested.
No, my lord, page 29, my lord.
No, we'll see next week.
My-
Revision in any case, revision probably.
Revision, my lord.
Revision, we have to revisit. Revision probably doesn't lie.
Revision, my lord.
Hmm.
There is a material irregularity.
What material irregularity? There is no material
procedure has not been
irregularity in
followed.
this case. No
And-
material
And
irregularity.
even the decree, my lord, what
You have
our
not
primary
raised
ground is, my lord,
regarding the jurisdiction also. Never ever. First time you are raising here. You have never even if you appear also. You only sought for some time only. It appears that you accepted. He has a power. They have a power.
when the quorum is non-existence, my lord. Because, my lord, as per section 5 of the AFR, my lord,
Hmm.
the village authority of concerned village can, my lord, adjudicate the matter, my lord. None of the plaintiff and the, my lord, defendant. recite-
Why you did not raise this? If one sentence, this Gambura or this male cannot decide the present case because I am not resident of your village. Then they'll tell that what is the jurisdiction of that male or the Gambura.
My lord, I can challenge this honorable, before this honorable court also.
Challenge before challenge in the you have not challenged this one also, the decree.
Or tomorrow someone from, my lord, Itanagar starts a mail, my lord. Village decision.
That is why
Department-
tomorrow, any day, anyone issue notice, immediately raise objection, challenge that in the revision. That, against that revision lies. The person doesn't have any jurisdiction in issuing this notice.
Even the decision, my
We'll,
lord,
we'll just set aside in class.
when the, even
But
the-
here is the case, he has already been arrested, you accepted everything, and then now coming,
even this.
you challenge the summon order.
We can.
So many
decision
summons
can
were
be
issued
challenged, my lord.
against you.
Even decision can be challenged, my lord.
Decision can be challenged,
Yes, my lord.
but then you say, you accepted before that. After acceptance, how you can challenge?
When the forum itself is not available, my lord, it's not a non-existent forum, my lord.
You accepted the authority of the Gambura, and then you praise for some time.
That is a non-existent forum, my lord.
You could have said that there,
Yes, sir.
and then immediately challenged before sending you to jail or before execution proceeding proceeded. Okay.
Right.
Matter number 3,
Wait, please, Lordship.
Yes, ma'am.
My lord, the petitioner was arrested on 2/5/2025. And since then, he's under custody. My lord, during his custody, he had filed bail application initially before the JMFC. May I just take your lordship to Annexure 5, the order passed there. Page 23, my lord. The grounds assigned, my lord, it is fairly intriguing. My lord, may I read, my lord? Okay, today case is fixed for hearing on bail. Landed
Para,
paragraph, last paragraph, my lord,
page 23.
23.
Okay.
My lord, considering the criminal antecedents of the accused person,
No, page 23.
page 23.
Para,
Annexure 5. Annexure 5.
okay, there is a paragraph, 1, 2, 3, 4, 5.
Yeah,
Which
last
paragraph?
paragraph, considering. Well, these are all technical. I can just read also all this. Today case is fixed for hearing on bail.
No,
I think the paging.
pagination, is it correct? The order dated 2/7/24.
25/9/2025.
No, that is 25/9. Are we in the same petition?
I think mostly
18 AP,
yes, 18.
18 page.
Page 22 or 23.
22 is order dated 2/7/24.
Well, this is
What order? You are reading order dated
well, just is maybe passport.
25, 25/9.
25/9.
Okay, this is page 21.
Page 21.
Yes,
I don't know, but so
in bail application,
in the bail application, yes.
44/25.
Now, my lord, the last paragraph, my lord.
Considering,
Considering the criminal antecedents of the accused person, I am not inclined to allow the bail application.
no,
Accordingly, bail application is rejected and disposed of. Now, my lord, this, we have again filed the bail application before the district and session judge.
this was 25/9.
25/9,
So he was arrested in connection with 309.
yes.
What is this 309 for?
My lord, it is robbery,
And,
punishable by its minimum 7 years.
okay, 3, 5,
Then, my lord, I'll just take your lordship to page 24.
24.
15/1/26 order that
Yes,
now lordship may come to page 25, paragraph 5. Let me read from paragraph 5 onwards, my lord. I have carefully perused the records of the case and seen that there are several incidents of dacoity, oblique robbery on the highway where miscreants forcefully snatched goods and belongings, including money from the travelers during wee hour of the night. Many of the victims have not even filed complaint, and as of now, there are total 6 cases pending against the accused persons, that is such and such and such and such and such, for commission of offenses of highway robbery by the accused persons. Case records as called for is received by this court. On careful perusal of the case record, it is observed that there is direct involvement of the accused persons, namely Pate Bagang and Urang Tako, in commission of highway robbery in different cases. It is further observed that when the IO had submitted charge sheet and the case is under trial, the period of detention does not play any consideration for granting bail as provided under Section 187 BNSS. It is further observed that the cases are already in trials and there is no inordinate delay in trial of the accused person. In view of the materials showing that accused persons are habitual highway robbers and there are sufficient incriminating materials on case records, which does not inspire this court to grant bail to the accused person. Accordingly, succession is disposed, bail is rejected. My lord, in this ground, my lord, I have 2 legal submissions, my lord. The first is that the consideration of bail cannot be on the basis only on the antecedents and the pendency of.
Yes, that is true.
Secondly, my lord, there is a specific finding, paragraph 6, my lord. It is clearly mentioned by the Honorable learned the session judge that the case is, the charge sheet has been filed, case is pending trial. Now, he has already come to a conclusion that there is direct involvement of the accused persons, my lord. That is a pre-trial judgment, my lord. So, this cannot be the ground for rejection of the bail.
No, but in para 7, he has
Yes.
made
in
an
view of the
observation
material showing
sufficient
that
incriminating
are
material.
habitual highway robbers, and there are sufficient, my lord, whatever may be, my lord.
But whatever the observation may be, but then he has found out that the involvement of the accused.
My lord.
So that is a ground probably for the rejection.
No, my lord, this he had mentioned this case number 40 of 22, 176 of 2022, my lord. The name of the accused persons does not appear there.
Okay.
The name of the accused persons appeared only in 3 cases, which I have mentioned in paragraph 21 of my declaration, my lord. So, in any case, my lord, pre-trial judgment
That is true.
that cannot be entertained at this stage, my lord.
Where have you stated that you don't have regarding your antecedent in paragraph?
Paragraph 8, 9, 10. Explanation is from 9, 10.
8, where?
8 is only description of what had happened.
No.
Para
That
21,
you don't have any criminal antecedent.
Para 21,
Where?
Lordship. Para 21, Lordship. Page
Para?
number 11, Lordship.
21.
Yes, Lordship. Page number 11, Lordship.
Okay. Substantive.
Applicant here, Lordship, mentioned 3 pending cases, Lordship.
Para 21.
This
Yes,
is as
the-
per the, I got the new directions.
As per the notification.
Yes, para 21 it is reflected.
Yeah,
Kindly read where.
That the humble applicant begs to submit that except this bail application.
Oh, that
there
is
no
not
other
para
bail
21.
application filed before.
Just a minute. That is not para 21 again. 22.
the humble applicant begged to submit.
No. The
Except this bail
applicant
application,
beg
there
to
is
submit
no
it
other bail
except this
application
bail
filed
application.
before any-
Okay, that is 22. That is para 22.
including, yes, Madam, paragraph 22. The prisoner is alleged accused in Simple
Okay,
case
okay,
75 of 23. In this 75 of 23, I have already been granted bail and which is annexed annexer 6.
Okay,
Ita PS case number 498 and Bandadewa PS case number 8 of 2028. But here in actually in 498 of 2025, we have tried to find out the records, but records is not available in the registry of the
okay,
court.
okay, anyway, that fulfills the requirement.
Yes.
Okay, anyway, so what we can call for the,
record
what,
close.
call for the
TCR.
charge sheet, already charge sheeted.
Sir, sheet submitted, but trial has not yet started.
Okay, call for the record.
Yes.
Only one submission, Malad.
Yes.
He's almost in the custody for the almost 10 months now,
What is the punishment, prescribed, punishment?
7 years.
7 years.
Yes. So anyway, Malad, we are ready to abide by the
Okay.
any terms and
Let
conditions.
us see the record. Let us see the record. Okay. Only after recording, you can pass an order. Heard Mr. T. Perting, Land Counsel for the petitioner. So I also heard Mr. Lawyer, Land PP for the state.
No good explanation.
This is an application file under section 483 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for release of the accused who has been arrested in connection with Bandadua BDW PS case number 08/2025 under section registered under section 3094 3
Para numbers.
stroke. It's 3/5, I think, not 3/5. 3 with bracket 5 of the BNS.
Yeah, the 3/5 is lordship, common intention lordship. Earlier,
No,
24
3/5.
yes, lordship.
3/5.
No,
Oh,
not actually. it
3
should
within
be,
bracket 5.
Yes, lordship, it
Yes,
should be.
3 within bracket 5. Start. Mr. Lawyer submits that the case has already been charge sheeted and he may be granted time to produce the case record from the staff. Call for the trial court record. Scan copy of the trial court record. List this matter. Next week.
Next week, lordship.
Okay.
Definitely.
Term number 4 also
Similar order.
similar order.
Oh, similar order. Okay, same person.
Yes, same person. Only
Yes,
the
sir.
case number is different.
Okay, okay,
He
Case
was
number.
arrested in this case. He was found arrested.
okay. Item 4. In item 4, the name would be same, but then the case number would be just not the case
08
number.
of Only
Another PS case
case
number
number
06/2025 under section 3094 stroke 3 within bracket 5 of the BNS. Okay. This here also, this case also has been charge sheeted. Here in this case also.
Yes,
same,
lordship.
same.
Okay. So he is habitual offender.
Yes.
Yes.
And if lordship, if para 6 appears to be true, there is pending pending cases, 6 number of cases lordship, then he is not entitled
Oh.
to be heard lordship. Since he is not disclosing he is suppressing the material facts lordship.
No, no. No,
he only mentioned three
no
cases.
FIR.
He only mentioned 3 cases lordship.
Otherwise,
No, no, he revealed. He has
other-
stated that.
otherwise, my lord,
Hmm.
if the landed PP is raising this question,
Hmm.
I put a challenge
Hmm.
to the landed PP. Whatever is in paragraph 6, if he does not produce the records of all those cases, yes, I will withdraw my bail application also. But if he fails to
Let us not
produce,
that extent.
fail to be a rule,
But it is better that he be there for some time. He is causing trouble to everybody, it appears. Okay.
he's 19 years old. Just
See, 19 years old, and of course, 19 years old, along with all those, he will come out as with a PhD degree then.
he has been properly briefed in the lockup also.
Hmm.
So he has assured that he will not commit any such further mistake. He's a young man, young boy, without any proper.
But then
process.
see, consecutively for 6 involving in this case is difficult.
He's involved only in 3 cases.
Hmm.
Records are available. Rest
Three-
is
three-
not there.
3 is also enough. Okay. Okay.
All right.
Item number 5,
Mayor, my lord.
Yeah.
My lord, this criminal petition has filed under section 528 of BNSS seeking quashing of maliciously institute FIR number
What is
65.
the allegation?
My lord, FIR has been lodged against the petitioner 1 and 2 under sections
352
Three-
lordship
yes, my lord.
of BNS,
Hmm?
352 of BNS and section 67 and 67A of IT Act. lordship.
IT Act, my lord. Yes, my lord. My lord, it is submitted,
350?
Lordship.
my lord,
What is?
79 and
What is
352 of
Intentionally
BNS.
insert with the intent to provoke breach of peace, lordship, which is a compoundable offense. So only the 67 and 67 is non-compoundable, lordship.
What is 367?
Punishment for publishing or transmitting obscene materials in the electronic form, lordship.
When the FIR was lodged?
My lord, it was lodged on the 17 of 9, 2026, my lord.
Okay.
My lord, if
Now,
we follow
what is the
this,
status of the case?
my lord, the status of case is that recently this according, it has been, it is the pending before the Chief Judicial Magistrate and the summon has been issued to the petitioner 1 and 2, my lord.
Or someone,
Someone, yeah.
already charge sheeted?
Yes, my lord. It was charge sheeted on the, my lord, 15/11 of 2025, my lord.
Okay. Yes.
Lordship, here the applicant did not specifically challenge the charge sheet, lordship, in the prayer, lordship.
Mhm.
He did not pray for crossing of the charge sheet, lordship.
My lord, in the first place, my lord, if we see the FIR, my lord, if we see the historical of this FIR, how it was lodged, my lord, it is a clear
No, He is,
counterblast, my lord.
he has also challenged the GR case.
Yes, GR,
Yes, my lord.
FIR and GR case, not the charge sheet, lordship.
My lord, this FIR was,
Proceedings. Okay.
my lord,
And the applicant number 1 was discharged from lordship, this lordship, charges, lordship.
Discharge.
In the charge sheet, lordship.
In the charge sheet itself.
Yes, lordship.
Okay, and only 2.
Yeah, only 2, lordship.
If you have been discharged, why you are,
my lord,
why you have come before this court if you have been discharged? No, any charge sheet has been filed against you.
Yes,
my lord, the summon has been issued by the Chief Judicial Magistrate, my lord, to the
Someone
Petitioner.
naturally, but then you will be discharged only at the time of framing charge.
is it, lordship, page number 40, lordship. Last paragraph, lordship. May I read, lordship?
Yes.
However, in regard to accused Api Sidiso, no evidence was found to indicate that she telephonically threatened or abused the complainant. In the absence of any incriminating material, she is not found to be involved in the
Have you
committal.
seen this? Have you seen?
my lord, my lord,
Even to discharge also, huh? They need to issue someone to pass discharge order. Because you were accused and then you have executed bail bond also.
My lord, in this para, it is mentioned, regarding the respondent, petitioner number 1, my lord, Api Shiriso, my lord,
Hmm.
who is a senior citizen. My lord, there is another accused, my lord, the petitioner number 2, my lord,
Hmm.
who is the person with disability, my lord, hearing problem, my lord. And someone has been
Okay,
issued
well-
to both of the accused and
We'll see the record then.
Yes, sir.
Okay. So, had Mr.
Jia Romching, my lord.
Lanark counsel for the petitioner.
My lord, if I may, my lord. My
Yes.
lord, until if you hear a call for the record and all, my lord, if the summon or the case which is in the JMFC, it may be stay, my lord.
Why? You appear there, you are going to be discharged. You'll get the discharge certificate there, you'll be happy.
Yes, my
You'll
lord.
be happier.
Yes, my lord.
Why you are afraid of appearing before the court when you are going to be discharged by the court?
Well, since in the para which is mentioned here,
Stay will see prolong the proceedings. You will always feel that there is a case pending against you.
yes, ma'am.
Get a discharge order from the court.
Yes, ma'am.
When the next date is fixed then?
My
There
lord,
before the court
25th,
court?
my lord. Tomorrow itself, ma'am.
tomorrow.
Yes, ma'am.
That will be better for you. And then you make a prayer for discharge prayer for the other one also.
Yes, my lord. That
So
petitioner
that
number
if
2,
it
my
is
lord.
tomorrow, how do we stay? What, how it will help? Okay. Also had Mr. Loy Lanak PP for the state staff. This is an application filed under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, seeking quashing of the FIR number 65/25. Where is the PS case number? Have you mentioned? Where have you mentioned?
My lord,
We have not mentioned. Where is the
The-
PS case?
my lord, WPS Itanagar, my lord.
Where do I find?
My lord, it is in the,
It should have been in the course title.
my lord, it is in the front page, is there, my lord. My lord.
Front page where?
Synopsis, you will find in the synopsis, my lord.
Synopsis.
Yes, ma'am. In the petition. Front itself, my lord.
Okay. GNR, GR case number 843/2025, arising out of the where in the synopsis.
Yes, my lord.
Which paragraph?
Prayer also, Lordship.
Which paragraph?
Prayer,
Prayer
Lordship,
section.
page number 12, Lordship.
It's very difficult to find the case number also. Police case number, when you are setting aside a question of the police book. FIR number, PS case where?
Page number 12, Lordship. C, Lord, prayer number C,
Okay.
Lordship.
GR number 843 of
Arising out of
FIR number 65.
FIR number 65/2025. Where do I find the PS, women PS case number?
My lord.
Where is the FIR then? Let us see the FIR.
My lord, the FIR is on page number 25, my lord. You will find it on 25.
Women FIR. Here also it's not clear.
FIR, my lord.
What PS case has been registered? Kindly read the PS case number. PS or WPS? Where? Where do I
WPS,
find
my lord.
that?
WPS, Women
Where
Police
do
Station, my
I
lord.
find that?
My lord, the WPS number is 65 of 25 itself, my lord.
Where
But
do I find?
it's in the sentence, it's written in the synopsis, my lord. But in the prayer section, we
Synopsis,
have
where
just-
it is? Where in the synopsis I find?
my lord,
Where can I find?
my
The
lord,
synopsis.
after the index, right after the index, my lord.
That is there. Read the,
My lord,
read, where is the WPS?
my lord,
Synopsis also, which para?
Vera, my lord,
Where is the case number in the police station?
my lord, it is in the synopsis. May I read, my lord?
Read.
That the present petition is being prepared under the inherit.
No, read the police station case number, WPS case number, where? You have not mentioned, I think, land council, you have not challenged properly, you have to.
My lord,
mention
my
the
lord,
police
my lord, it
station
has
case.
been mentioned as FIR number 65 of 2025, dated 17
PS, which PS? I think you withdraw and then file a fresh,
My lord, it's,
probably.
my lord, it's there, it's
It
there
it
only,
will
my
be
lord.
better for you, land council, it will be better for you, because tomorrow.
My lord, my lord, my lord.
Wait, tomorrow the case is fixed. The one against whom no charge sheet has been filed, he or she will be discharged tomorrow. Okay, number one. And if charge friend against the petitioner number two, you come. And then if there is no cases against the petitioner number two also, you can come always. Day after tomorrow, you immediately come. Challenging. Okay.
My
And
lord, sorry for the
please mention the police station case number also, and submit the charge sheet also, mention the charge sheet also, and also the GR case number, so that we can properly mention the name of the case, name of the parties, name of the police station, name of the case number, and then set aside and request for you.
My lord, there was a minor misunderstanding, my lord. My lord, it is in that page number 25, my lord, in the petition. We have, page number 25, my lord, 25.
We cannot go and
My lord,
find out,
25,
go and find out from somewhere in the pages to quash and set aside in the petition. So you have to mention in the prayer also clearly, women PS case number so and so, under registered under so and so. If you want the case is to be set aside and quash, okay, you better withdraw and file afresh, and leave the petitioner number one. She is going to be discharged tomorrow. Okay,
so my lord,
Mr.
Jerome Ching, my lord.
Lani Council for a petitioner wants to withdraw this criminal petition with liberty to file afresh after making necessary correction. The prayer is allowed. This criminal petition stands dismissed or as withdrawn with liberty as prayed for. Okay. Yes.
Item number 6,
Right.
Briefly. Next.
May I please?
Okay, yes.
Your Lordship, in this application, Your Lordship, I'm challenging the order dated 23/01/2026, passed by the Special Judge Pokso is coming, Your Lordship.
You are agreed by order dated?
23/1/2026.
Okay. What order was passed by this?
By this order, Your Lordship, the accused has been charged, accused has been framed, charges has been framed under section 64(1) of the NS, which is punishment for rape, and section 4 of POCSO Act. Your
Okay,
Lordship.
so what is wrong in it?
Your Lordship, may kindly come to page number 14, Your Lordship. That's impugn order.
Page 41,
14, Your Lordship.
14.
Yes, Your Lordship. The operative person is at page number 15, Your Lordship.
Yes.
May I read, Your Lordship?
Hmm.
After hearing both the learned APP and learned Defense Council, and also upon perusal of the material report, it is found that though there are two dates of date of birth of the victim as reflected herein above, this court is of the view that the date of birth recorded in the first progress report of the victim when she was still in class 1 and 2 standard, which is supported by affidavit executed by her natural father.
Okay, informant. Also had Ms. Jimmy Ha and additional PP and Mr. G. Tarak, Lana Council for appearing on behalf of the informant, respondent number 2 informant, sir. The the councils for the parties submits that they have received paper book. Okay, stop, huh? Mhm. In view of the above, let this matter be listed for hearing after.
No, my lord, on second for admission hearing, my lord, it will not take time. It is on admission problem. If it is for,
Not yet admitted. Must have been
no,
admitted.
it is not at first time admitted.
Was this criminal revision? Okay,
Criminal visit
list this matter on
on
second for admission. Okay,
yeah, 2nd March.
2nd March for admission. Okay.
Online.
Item number 8,
Lordship, it's already been charge sheeted, Lordship. Charge sheet is submitted.
This is case diary. Okay, so case the record is to be called for.
Lordship, last time Lordship case study was called for,
Ah.
but today I have received the instruction that it is already been charge sheeted. The
Okay,
forwarding of
this-
the
okay.
charge sheet is here. my lord.
Okay. Mr. B. Taiporia,
Yes, sir.
Lana Council for the petition is present. Miss L. Hage, Lana additional PP, submits that. When the charge sheet was filed?
Lordship, 17th of February, Lordship.
Okay, during this pendency only?
Yes, Lordship.
Yes, sir.
Okay, immediately, no, next date.
Yes, Lordship.
Next-
Okay.
Next date only, Lordship.
Uh,
So he
Some-
may
some
approach
is-
before the
The
Lordship.
case has already been charge sheeted. Before, charge sheeted on 17 to 2026. So in view of the above, scan copy, in view of the above, let a scan copy of the trial court record be called for.
Yes.
Or you can file a bail
Yes,
application before the trial court.
Yes, Lordship.
Yes, Your Honor, even
Eh,
earlier also, Your Honor, it in case diary, they said that charge.
No, now,
Yes,
your bail was rejected earlier.
yes, Your Honor, all,
Now the situation has changed.
yes,
So you can approach the trial court since the case has already been charge sheeted. And then there is no scope for his influence or any hampering with the evidence. You file application first there before the trial court. Trial court will be the best court.
Your Honor.
Okay?
Yeah.
Because the situation has changed. Okay, Mr. Committed, no? On so and so, huh? So in view of the above, Mr. B. Taiporia, Lana Council for the petitioner. Prays that he may be allowed to withdraw this bail application with liberty to file fresh bail application before the trial court. Okay? The prayer is allowed. This bail application stands dismissed with liberty. Is prayed for. Okay.
Much obliged, Lordship.
item number 9,
Same connected matter.
Okay. Similar order.
Yeah.
Out of same FIR, Lordship.
Out of same FIR.
Yes, Lordship.
Okay.
Yes,
Similar order.
obliged.
Lordship, 10 is election petition. Lordship.
Okay, 12. Then next,
Item number 11,
we'll complete the other today, now, and then the election petition at 2.
Lordship.
Hmm. Yes,
Lordship, this is a criminal petition, Your Lordship.
yes.
Election under section 528 of PNSS Act 2023
Hmm.
for setting aside and passing of registered FIR advertisement to prevent the abuse of legal practice, Your Lordship. Your Lordship, in connection with GNPS case number 1525, Your Lordship. Your Lordship, this is the case allegations where does not constitute any offense, Your Lordship. Your Lordship may come to the deep fact of the case, Your Lordship.
Just a minute, huh? So,
May- May it please, Your Lord.
it's a contested case.
May I please, Your Lord?
Yes, sir.
I've just been informed by the amicus curiae. On the last occasions, the respondent, counsel for the respondent did not appear and therefore the amicus curiae was appointed, Your Lord.
Yes.
I've just been informed by him this morning that the learned counsel for the respondent had asked him that he'll be appearing in this matter, Your Lordship.
Okay,
So in that case,
not Morik Bagra.
if the respondent counsel has requested the amicus that he'll be appearing, let the amicus be,
Whether the
Matter.
respondent counsel appear.
he's not present today. He had asked him this morning. I've been informed by him, Your Lordship. He would test.
May I submit, my lord?
You were requested
Yes,
that he will be
Biswa-
appearing.
Biswajit Prasad and his,
Have you, whether he has filed any wakalat nama? not yet.
Yes.
he informed me that he Wakalatam already filed,
Already filed?
yeah.
Your Lordship,
But-
5 months back, he filed a Wakalatnama. But
Oh,
even after then, he is not complied this petition, Your Lordship. Repeatedly is making adjournment, engaging another counsel for even last occasion also, Your Lordship. Intentionally not complying this petition, Your Lordship.
his
Here,
name has been
Lordship, this
reflected,
is the-
just a minute, just a
Civil
minute.
dispute case, Your Lordship.
Whether his name has been reflected in the course.
Yes.
So Biswajit Prasad.
Yes, Your Lordship.
In second number.
Then what will do, one last opportunity can be given to him.
And moreover, my lord, in the petition, whatever they filed the petitioner, so many material is not available as per the we are supposed to be plead. So whatever the material along with the pleading, all are entered with the leading counsel, Biswajit Prasad, brief of the fact. So otherwise is natural justice impact, my lord. Otherwise is not supposed to be. Because what of the material supposed to be in the prosecutions, it's
Ah.
remain in not with me. So is whatever the material available is with the Biswajit
With
Prasad,
Biswajit. Okay.
leading counsel.
Okay, Mr.
It's better.
T. Ango, learning counsel for the petitioner is present, staff. Miss Jeannie, learning additional PP is also, hard Mr. T. Ango, huh? Also hard Miss Jeannie, huh? Learning additional PP, staff. Mr. Morik Bagra, Planet. Legal aid counsel. or-
Legal aid,
Legal aid
amicus
counsel.
curiae, yes, legal counsel.
For the respondent number 2, Samit Stat. At Mr. Biswajit Prasad, who filed Wakalat Nama to represent the respondent, for Wakalat Nama to represent the respondent number 4 this morning, calling for telephonic and requested that he would be appearing in this case in for respondent number 2. However, Mr. Biswajit Prasad is not present in the court today. It appears that Advocate Biswajit has filed Wakalat Nama when way back on 13/11/2025. But never appeared. Staff, huh? Be that as it may, the Advocate Biswajit Prasad is given one last opportunity to appear on behalf of the respondent number 2. huh? Okay, okay.
City already been called for very earlier, Your Lordship.
We have
It will not be punished. Your Lordship, the IO has already verified the matters, but there is no.
Miss
sufficient
Jenny
evidence
Lan,
to recover
additional
against me,
PP,
Your
submits that the trial court record. CD,
CD, Your Lordship.
or not a charge sheet.
Not yet charged.
The case is of, okay, 25 only. The case study, okay. Earlier call for,
Yes, yes.
It was called for
Okay.
on,
on the next, this
January
matter again on, again after
2 weeks. Your
2 weeks, on which date?
My lord,
Vinny shall produce the updated case study.
my lord, In my
Scan
prayer,
copy of us,
My lord.
updated scan copy of.
my lord, in the prayer of the lead blood conducting council, he gave the 3 dates, 16, 23, 24 of March.
Okay,
16,
16 March, on which date?
16 of March.
Its initial produce,
I don't see.
the updated case study.
16
Scan copy of the case study, huh? Scan copy, huh?
Okay, 16 of March, Monday.
Okay. So then, this 12 and 13 also will complete.
Matter number 12,
Much obliged.
Obliged.
Yes.
The matter is fixed for mediation. For
Yes.
mediation.
So who is for the other side? You ready?
Yeah, I'm ready.
Who is for the other side? What about the other side?
I was informed that they are also agreed.
Who informed you?
The council, Miss Rimi, Ipa K. Rimi,
Mr.
J. Karbak,
J.
Karbak.
You are J. Karbak.
Yes,
Your name is there.
yes, sir.
It's, I cannot see. Ratan, Tagu, Ete, Mortem, Doji, Dorji. Your name is not there.
Your Lordship, on behalf of K. Lawyer.
Mr. Karbak, Land Council appearing on behalf of Mr. K. Lawyer, Land Council for the appellant. Mr. Karbak submit that the none appears on behalf of the respondent. However, Mr. Karbak submits that. Who is the counsel for the other side?
K. Rimi.
K. Rimi. K. Rimi is not present today.
No,
K. Rimi, Land Council appearing on behalf of how many respondent?
one.
Sole respondent. One, only one.
Yes, sorry.
Okay, sole respondent requested him that requested him for referring, requested him to make a prayer for referring this matter before the mediation center for settlement of, for settlement through mediation. Staff, para. This case has been listed for referral to the special mediation drive, mediation for the nation. Staff. Case submitted by Mr. Karbak. The parties voluntarily agreed to the parties are ready and willing to settle the matters through mediation. Staff. On perusal of the record, this court also find that there is an element of settlement of the matter through mediation. Staff. In view of the above, let this matter be referred to the mediation center, Guwahati High Court, Itanagar bench. Staff. The registry is directed to appoint a mediator and transmit the record, refer the entire record to the mediation center by fixing date for their appearance and the date for their appearance before the mediator. Stop. Okay. List is matter. After
Your Lordship, there is an
receipt of the mediation report.
there is an interim order. Maybe continue
Yeah.
till the
And that-
disposal of this mediation process.
There is interim.
Yes, yes.
Okay. The interim order pass, others shall continue till In the meantime, the interim order pass earlier shall continue. Okay.
Obliged. Item number 13,
May I please, Your Lordship?
Yeah.
Lordship, in this matter, I am appearing on behalf of the petitioner, Lordship.
Hmm.
Since Lordship, this matter may be fixed after 2 weeks because I need to communicate with my client, Lordship.
Okay, Mr.
T. Garam, Lordship.
T. Garam, allow me counsel for the petitioner. Prays for 2 weeks' time to obtain necessary instruction in this regard. Just a minute. This matter has been reset for referral to the special mediation drive, mediation for the nation staff. Mr. T. Garam, allow me counsel for the petitioner. Prays for 2 weeks' time to obtain necessary instruction in this regard. They are allowed to list this matter after 2 weeks.
Lordship. And there is an interim order that
The interim order pass earlier shall continue till the next date of listing.
deeply obliged.
only election petition is there. Lordship.
Hmm?
Only item 10 is there. Lordship.
The election matter
Yes, Lordship.
that will continue at 2. Lordship.
Item number 10, election petition 2 of 24.
Name.